before the special leave petition, which had been specially fixed for hearing on 9 November 2011, could be taken up for consideration. Mr. Tiwari, learned counsel advocate, appearing for the petitioners, Messrs. Bharat Steel Tubes Limited, submitted that contempt petition under bracket civil number 271 of 2010 had been filed in regard to willful and deliberate violation of the order passed by this court on 8 October 2010 by the alleged contemners in entertaining bids for the auction proposed to be held in respect of the petitioner property despite the said order. Mr. Anand submitted that in relation to an order passed by the Debts Recovery Tribunal Delhi on an application filed by the petitioner under Section 17 of the Recovery of Debts Due to Banks and Financial Institutions Act 1993, herein after referred to as the Debts Recovery Act 1993, a direction was given by the tribunal on 15 September 2010 to the petitioner to deposit a sum of rupees 35 crores with the Industrial Finance Corporation of India Limited without prejudice to its rights and contentions. The respondent was also directed not to implement the possession notice as well as the public notice published on 13 September 2010 till the next date of hearing. Against the said order, IFCI Limited filed miscellaneous appeal number 352 of 2010. Aggrieved by such direction, the respondent had moved writ petition civil number 6652 of 2010, in which an interim order was passed by the division bench of the Delhi High Court on 29 September 2010, directing that during the pendency of the public notice dated 13 September 2010, but the bid was not to be finalized since a winding up order had been passed in respect of the petitioner company in the recommendation of the Board of Industrial and Financial Construction, and the official liquidator would be associated with the process of auction, and the amount received by the petitioner from prospective purchase as earnest money under the bids would be kept in a no-line account. Mr. Anand pointed out that such an ex parte order was passed on the position that there were dues to the extent of rupees 1100 crores payable by the respondent, and that proceeding had also been taken under Section 17 of the Scrutinization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, even though the BIFR had recommended the winding up of the petitioner was still pending. Stop.